We'll
This
have
conference will now be recorded.
Gee, now it's being recorded. All my good remarks, I have to say them again. No, but anyway, so we will record this so that you have the opportunity to hear our presenters today with the content that you need. And finally, I did mention our website. There is a tremendous amount of information on our website, foundationdor.org. It's actually in all of our materials, or if you go on the diocesan website and you go to giving, you'll see a link for the foundation. But on our homepage, you will see at the top right-hand corner a button for planned giving. And in that button, it will take you to a landing page for planned giving, and then you'll have the option to go to forms. You'll be able to see bequest language. You'll be able to see some videos of some people who have donated in the past and have shared their stories. So there's information for you, your financial planner, your attorney. The other reason you would want to go on our website is that part of today's discussion, we're going to talk about a personal planning workbook. And that personal planning workbook is available by contacting the foundation. And Ryan will speak to it today, but it really is a guide to help you think about all the things you need to think about, not just in terms of perhaps writing a will, but what are all the things you need to do to get things in order so that at the time of your passing, your wishes will be kept, whether they're wishes about how you want a funeral, whether they're wishes about how you want to distribute some of your more personal possessions, whether there are things about what church you want to be buried in, what songs would you like at your mass. So again, it's not just the financial and legal planning that gets you to think about this document gets you to think about, but also some of the more practical matters. And so finally, I just for one moment want to talk a little bit about planned giving. It is a very personal decision that you make together with your family. We ask you to think about discerning potentially a gift of even 2% of your estate to your parish or the diocese. A lot of people think about what should I leave? How should I leave it? I don't know what's going to be left. But if you think about it in terms of a percentage, sometimes it's a lot easier to think about a percentage. And here at the foundation, we are so grateful for the people who have made a bequest to the diocese, made a bequest to a parish. And again, our goal here today is to help you implement your wishes. That's our goal, give you the tools that you need. We're available to meet with any of you over the phone here in the office. So now I'm going to turn it over to Ryan Flood, who is our planned giving specialist, and he'll talk with you about all the preparations you need for planning. So Ryan, thank you very much.
Thank you, Maureen, and welcome everyone. There's just a few people who still have their cameras on. If you just double check and want to turn your cameras off, most of you are muted. There's a few not muted, so just double check that to make sure your microphone is muted and your cameras are turned off. As Maureen said, my name is Ryan Flood. I've been involved here with the diocese for over 13 years and now at the foundation helping as well. And it's been a great joy to work with many of you over the years. There's certainly a lot of constant changes too in gifting and tax law and legal repercussions and things like that. So we are very blessed to have Charlie Davis join us today. In about 20 minutes, Charlie will join for his section of the important legal documents that every estate needs. Thank you for all your wonderful questions. Through the course of the presentation, we should answer the majority of them. If not, please let us know. I did notice one that was more geared towards a certified financial advisor, which we do not have on the call, but we can certainly give, we'll get back to that person who had the that particular question. We'll get him some resources there. But most of your questions should be answered during the course of the presentation. If not, like Maureen said, please just let us know. Give us a call. We're here to help. There's again no obligation to give or anything like that. This is an educational seminar, and we want to help you with your discernment, how to make gifts to your family, to friends, to charity as well. So we want to encompass everything today. Okay, next slide, please. When one starts to contemplate their legacy, some of the big picture things you want to think about is what mattered most to you during your lifetime. You know, for most people, it's their family, friends, community, their church, their parish. What mattered most to you? How do you want to be remembered? Some people want to be remembered with a family named endowment, and some people want to be totally anonymous. That's up to you. Passing on values more than valuables. We live in a society where a lot of people have a lot of things today, but it's very important to make sure that the values of past generations are passed on to newer generations. And a lot of that can be done through our ministries here in the Diocese of Raleigh. And how do you get from here to there? Well, that's what we're going to talk about today. Next slide, please. Okay, a couple questions you want to be thinking about, before you go see an attorney, before you go put things together. The more organized you can be, as Maureen talked about, the workbook is a great help. We'll make sure everyone gets a copy of that. The more time and resources you will save. So a question that I like to ask is, what is a person trying to accomplish with their plan? So what are you trying to accomplish when I think about that? How much will I or my spouse and I need to live on for the rest of our lives? That's an important question as well. And how much should I leave to children and grandchildren, right? You can leave something, you can leave a percentage, you can leave a lump sum, you could leave an income stream over a term of years. You don't have to give it all at once. There's many different ways to give. And what should I leave to charity? Now the next slide please, is the Catholic Estate and Personal Planning Workbook. This is a workbook that we have given out well over 1,000 now in the time we've been here. It is not a legal document, but what it does is it helps put all one's ideas and information in one location, and then you can use that for your pre-planning. So when you go to meet with your attorney, you have everything there at your fingertips. It also has a wonderful list of resources for what to do after someone passes away, grieving resources, a lot of information in there. It's a 34-page comprehensive workbook. We can't get into it all today because that would be a seminar in itself. But if you would like a copy, please let us know and we'll get that to you. A little history about this book is that a former colleague of mine put it together with an attorney friend of his because of a situation with a relative who passed away without a will and without any estate plans. Charlie will talk a little bit more about this in a moment. This person died intestate, which means they had no plans. And so it was a big, big headache. So in order to help people get more prepared and not go through the headache of that, of not having a will, he put together this workbook. So it's been very helpful to a number of people. We hope it'll be helpful to you as well. We give it away at no charge. Next slide, please. Some of the benefits of planned giving: mutual benefits to you, to yourself, to your parish or favorite charities. You can set up simple gifts through your will or trust, or you can set up split interest gifts. And we're here to help you with these ideas. And a lot has to do with timing. For instance, not much timing involved in changing a beneficiary designation, but there's a lot of timing involved if you want to set up a gift annuity or a trust. Usually it coincides with this sale of a capital asset. I'm working with a person now who has some rental properties with a very low cost basis. If she were to sell them, she'd incur a large capital gain. What she's trying to do is time this and put together a gift where she can transfer the asset into the gift annuity, take the charitable deduction, and then get income for the rest of her life. So a lot has to do with timing in a lot of these gifts, which we'll talk about in a moment. Next slide, please. Then some of the types here, we have life income gifts, gifts from the estate, and different funds here at the foundation. Donor designated funds and endowment funds being the most popular. And you work with your attorney setting up a will or trust. And we'll talk about the life income gifts in a moment. Next slide, please. Some of the popular ways that people are giving today. The first, you can go to the next slide, please, is the IRA charitable rollover. This is a way for people who are 70 and a half and older to make a gift directly from their IRA to a qualified charity and not have to count that as income in the year that you make the gift. It's a wonderful way to give because it's an above the line deduction. It would just come over to the charity, and then you would get a gift acknowledgement from the charity, and you don't count that as portion as income. Because sometimes with people's required minimum distributions, they can get larger and they could, mess up other things, put you in a higher tax bracket and do things like that. So a good way to avoid that extra income is just to give it. And you can give it, to multiple charities. And it can be part of your RMD. So the IRA charitable rollover. Starting in 2023, the new age, if you turn 72 in 2023, the new age to start your RMD is 73. So as you can see there, even though you have to be 70 and a half or older to make the qualified charitable distribution, you do not have to start taking distributions from your IRA until you're 73. Therefore, most people wait till they're 73. When the law was written years ago, it was 70 and a half, and that 70 and a half hasn't changed. And we'll talk about in a minute here how one can use an IRA rollover to set up a gift annuity. Next slide, please. Real briefly here, these are just questions for you if you're meeting with your financial advisor sometime this year. I don't have time to go into this slide. It's quite lengthy. I'll just touch on a couple of bullet points. They're mostly as reference points for you to bring up with your financial advisor if you have one. Secure Act 2.0 came into existence right at the end of 2022, was approved and came into law 2023. And as I mentioned before, the RMD, if you turn 72 this year, you don't have to take your required minimum distribution until you're 73. And then it extends all the way up to age 75 in 2033. Penalties are reduced. RMD is no longer required from certain accounts. Catch-up contributions will increase in a few years. And there's other things. So if you want to just jot that down or let us know, those are some points to bring up with your financial advisor. And the next slide, we'll talk about briefly here one of the new benefits of the IRA charitable rollover. This came into existence this year where an individual can do once in a lifetime tax-free distribution from your IRA for a charitable gift annuity. Now you can do the regular qualified charitable distribution from your IRA any year you want to charity. This is for a life income gift for a charitable gift annuity. It works the same way. You would just request the transfer. The transfer would come over. It's all the way up to $50,000 and anything in between. But you really have just 1 year to do it. So if you're going to do one for $5,000 or $10,000, I think you're going to do more. You should try to do them all in 1 year, and the maximum amount is $50,000. The life income payments will be 5% or greater. And it will lower your taxable estate. The other benefit there too is that if it's fixed income for the rest of your life. We'll talk about gift annuities a little more in detail in a moment. But with the volatile stock market, it might be a good time to do something like this. Again, it's an IRA charitable rollover to a gift annuity. And instead of taking out those funds, let's say that $25,000 or $50,000, and incurring all that income tax at that time, you can put it into a charitable gift annuity, get income payments for the rest of your life, and spread that taxable event out over the lifetime of the gift. 15 years, 20 years, 25 years. So that's another neat thing about the IRA rollover to a gift annuity. Again, it's brand new. If you would like some more detailed information, please contact me here at the foundation, and we can happy to discuss that with you and get you some more information. You may again bring it also up with your financial advisor, but it's a neat way to lock in some fixed income, and especially if you have some gains in your retirement plan there, and you have to take your RMD anyway. It's neat to do it with a charitable gift annuity. Next slide, please. Again, qualified charitable gift annuity is pretty easy. I'm sorry, qualified distributions. You would just contact us here at the foundation. We have all the information you need to get to your plan provider. They will take that information, they will issue the check, and it'll go directly to the charity. Now, you can have the check sent to yourself, and then you can send it to the charity or charities, but just keep in mind the check has to be made out to the charity. Can't be made out to the individual, or that will cause a taxable event. To take full benefit of the qualified charitable distribution, the check would have to be made out to the charity and sent directly to the charity, or sent to yourself, made out to the charity. You can make a copy of it and then send it to the charity. But that's how the QCD works, and we have instructions on our website, or you may contact the foundation for more information. The next slide, we'll go quickly through these next few ones here, and I'll turn over to Charlie, is that we're staying on the idea of the IRA. It is a wonderful gift if one is charitably inclined to leave a percentage, as Maureen said, 2%, 5%, 10%, however you'd like, because any percentage of an IRA left to charity goes to that charity tax-free. Whereas the portions that are left to non-taxable entities, it's going to them, but it's going to them at their income tax rate because those funds haven't been taxed before. So a beneficiary designation is a neat gift to make to charity. It doesn't cost anything. All you would do is request the change of beneficiary form from the institution, if it's Schwab or Vanguard, or you would make those updates, send it back to them, send the charity a copy if you'd like, and then you're all set. If your circumstances change, you can always change it. Again, it's nothing set in stone. So it doesn't cost anything. It can be changed easily. And it's a wonderful gift to use for charity. We talk about some assets, are good to leave, good assets, quote unquote, leave to family, good assets leave to charity. An IRA, a percentage of an IRA is a good asset to leave to charity because of the taxable issues it has. Other assets that get step up in cost basis, like homes, a regular stock account, things like that, those are better to leave to family because they get a step up in cost basis on the date of death. And then if they're sold quickly after that, there's really no tax implications. So just keep that in mind. And if you would like the information for the foundation, I was just working with a person down in Wilmington. He's leaving his parish as a beneficiary of an insurance policy, similar idea. So it would come to the foundation for the benefit of St. Mark Catholic Church. So you got to make sure you have the wording is correct. We have all that wording for you, and we can get that to you. Next slide, please. If you're going to update your will, again, it doesn't cost anything extra to name your favorite charities in your will. Just make sure that you have the wording. If they suggest if they have wording, the legal title is very important, and the tax identification number. In some cases, you may need that. So it's important to have that information with you as you're updating your plans. Next slide is the life insurance, as I just mentioned. Same idea. If you want to leave a charity as a beneficiary of a whole life paid up policy, you can do that. Or if you don't need the policy anymore, I've worked with some people who would just give it outright to the charity, make the charity owner and beneficiary. We can help you with that. And then most people are eligible for a charitable deduction on that portion. The next slide is appreciated securities. We've had, again, a volatile stock market, so lots of ups and downs. But just keep that in mind that when giving securities, you don't pay the capital gains tax. You can give them outright, or you can give them as part of a split interest gift. You can deduct up to 30% of your adjusted gross income on gifts of property, such as stocks. And if you can't use up all that deduction in 1 year, you have a 5-year carryover or carry forward. So keep that in mind. If you don't use it all up, you don't lose it. So keep that in mind, but you do have to make sure you hold the securities for more than a year. A lot of people, if their parish is having a capital campaign or there's some larger campaigns going on, people use their appreciated securities to make those gifts. So in some cases, it might work really well if you've held the stock for a long time and you have a large gain in the stock. Gifting that is a way to take advantage of that. Next slide, please. U.S. savings bonds. Keep that in mind too. I talked to a lot of people who have these in shoe boxes or lock boxes, but they, again, very similar to the IRA gift. When left to non-charities, they're taxable. But if you have specific wording in your will, they can be transferred electronically or physically to the charity and let the charity cash them in, and they don't pay any tax on them. The U.S. savings bonds. Do not endorse the back of them. That'll cause some issues. If you need any information on how to that specific wording, please contact the foundation and we'll get that to you. The next slide is, as I mentioned before, the charitable gift annuities. These are becoming popular again. I've been doing this for 23 years, so their popularity goes up and down. But now with a volatile stock market, charitable gift annuities are a way to lock in your gains if you have some, and set up fixed income for life for an individual or individuals. You can have a 1 life or a 2 life gift annuity, and the rates have gone up this year in 2023. We follow the gift annuity rates that are by the American Council of Gift Annuities. They do all the actuarial tables, so it's safe to use those. So we use those rates. We don't offer any higher than those. But it's a wonderful way to make a gift and get income for life. And then at the end of the life or lives, the remainder goes to the charity. You can set up an immediate gift annuity, you can set up a deferred gift annuity, or you can set up what is called a flex gift annuity. There's many options there based on your income needs. And as I was mentioning before, a lot of these type of gifts have to do with timing. So if you're planning on selling an asset, a capital asset, and you know you're going to incur a capital gain, a gift annuity is a good way to help to offset that gain in part or in whole, and receive income for life. So keep that in mind, as like the example I gave earlier about the person with the rental properties. She's going to incur a large gain, but she's using a gift annuity to help offset that gain. So please, as I keep that in mind. Another way that charitable gift annuities work well, as I work with a gentleman, he was living in Hillsborough at the time. He set up a gift annuity for his wife and him, and using his mutual funds, where again he had a gain, but he set it up so if he were to pass away first, his wife would keep getting the income payments uninterrupted, for the rest of her life. So it's a good way to set that up as well. And any information you need on these, if you need a gift illustration, we can put that together. Any further conversations with your advisors, we'd be happy to have them. But there's a lot of neat things you can do with gift annuities. Next slide, please. Charitable trust, we won't get into a lot of this today. It's just more of a sophisticated gift annuity, you could say. And if you have more complex assets, such as more complex real estate or business interest, a charitable trust works well. Next slide, please. And endowments. Endowments here at we have over 150 of them here at the foundation. It's a way to set up a gift and support your favorite charity, if it's Catholic Charities or a Catholic school or your parish. Endowments work really well because the principal stays intact and only the income and interest are used annually to help with the ongoing needs of that organization. But the principal stays intact over time and keeps building and growing. Another neat thing here about the endowments at the foundation is that we use the USCCB Morally Investment Guidelines. That means none of the investments are in industries or organizations that are against Catholic teaching. So and they're constantly screened for those immoral organizations that are doing that. If it's anything, with to do with nuclear weapons or pornography or anything like that, those investments are screened to have only morally acceptable companies in them. So that's the endowments. Next slide, please. There's a little information too. Professional money managers. I talked about the investment guidelines. You can make any contribution at any time. You'll get quarterly reports. There's an annual grant distribution, and grants are made in accordance with the mission of the foundation. These are very helpful, also for rainy day funds for a parish and things like that. So keep the endowment program in mind. Again, people will do them as a family endowment or for an individual in memory or in honor of someone. So there's a lot of neat things to do with the endowment program. Happy to answer any other questions you may have. Just let us know here at the foundation. And the last slide before I hand it over to Charlie is just when you're thinking about your planning, it's thinking about a faith declaration, right? A number of people now are starting their will off in the name of the Father and the Son and the Holy Spirit, right? Very, very important, right? There's nothing you say you can't do that, and it's a way to evangelize. There's also a way to write in forgiveness provisions, right? If you don't have a time or not the ability to ask for forgiveness, you can put that into your estate plans. Tithing is also important, and Gregorian masses, that is 30 days of consecutive masses for the repose of a soul, very important as well. So we have those resources if you need them here at the foundation. I'm going to turn the presentation now over to Charlie Davis, an attorney here in Raleigh. He's going to go through some of the important estate planning documents. And we'll go from there. Take it away, Charlie.
Thanks, Ryan. I hope everybody's having a good day today. You can move on to the next slide, please. So I'm going to talk briefly about the estate planning process. There's a bunch of documents that are important in that process. I think it's important to remember, though, that your estate plan is a process and it's not just a set of documents. Your IRAs or life insurance policies have beneficiary designations that you'll need to check in this process. You'll want to have your attorney, your CPA, your faith advisors involved in your plan as well. So it's not just about having a piece of paper that says who's going to get your assets after your death. It is really an entire process and making sure everything is aligned. And so we'll talk about that today. So this is a list here of the documents that tend to be the most important in a plan, and we'll go over each of them in succession here. So next slide, please. Okay, so a durable power of attorney for finances. You've probably heard of this before. Sometimes it's called a financial power of attorney as well. This is one of the most important documents for you to have in an estate plan or just in general. So this document appoints someone to make financial decisions for you in the event you're unable to do so. So that could be because you are incapacitated. It could also be simply because you're, say, out of the country and you need to close on the sale of your home or the purchase of a new home. A power of attorney like this, a financial power of attorney, allows someone to act on your behalf for that. So they can, they can do real estate transactions, but they can also, just go to the bank, access your financial records, instruct the bank to do certain things. They can write and sign checks. And so this can be very important for anyone to have. It may be that you would never need this anytime soon, but it's good to have it so that if something were to happen to you unexpectedly, you have a document in place that would allow someone access to your finances. If you don't have a power of attorney and something happens to you that results in you becoming incapacitated or unable to manage your affairs, you would have to have a guardian appointed so that that person could access your assets. You want to avoid that if you can. It's a court supervised process, and so it's just good to avoid court involvement anytime you can. And generally, this financial power of attorney will help avoid that process. Sometimes you can see these things called general powers of attorney, and that just means that they grant broad general powers to someone to act on your behalf. There's also these are sometimes drafted in a more limited fashion, and that is called a limited power of attorney. And that will grant only a few powers to your agent. Usually limited powers of attorney are used for single transactions, like if you're going to be out of the country and you need to close on the sale of your home, you can appoint someone to, sign that deed. And so that power of attorney, is only going to give them the power to do that, and it's going to be limited in duration. So, and it would expire, say, after 30 days. And so usually in the estate planning process, what you're going to have is a general durable power of attorney. Durable means that it lasts through your incapacity. So it used to be that powers of attorney were not automatically durable, which meant that if you became incapacitated, your power of attorney would lose its effectiveness. And of course, that is exactly the time when we want the power of attorney to work. So they're all typically drafted these days to be durable. And actually, the North Carolina statute provides that a power of attorney, if it's drafted these days, is durable unless otherwise stated. So that's what that word means if you see it. You can also have different times of effectiveness for a power of attorney. Generally, the ones that are drafted these days are immediately effective. And so your agent that you've appointed in that document can act on your behalf immediately. You can also have what's called a springing power of attorney. And that means that it springs into existence. It is effective at some later time at the occurrence of some event. And so it used to be popular to have powers of attorney that were not effective until you became incapacitated. That's less common these days. In order to determine if you're incapacitated, that usually requires a certification from a doctor or oftentimes two doctors, and that can just be a pain to have to get. And so usually we say, look, appoint someone who you trust to, use this for your benefit only and not abuse their power. And let's just make it immediately effective so that they can use it immediately upon needing it. Next slide, please. Okay, so the next documents are healthcare related documents. So it's important to have a healthcare power of attorney. So just like a financial power of attorney, your healthcare power of attorney would appoint someone to act on your behalf. But in this case, they would be making healthcare decisions for you instead of financial decisions. This document is only effective when you are unable to make your own decisions. So as long as you can as long as you're not incapacitated and can make your own decisions, no one else can make your healthcare decisions for you. But it's good to have this because, you know, something unexpected could occur, or you could have a routine surgery and a decision needs to be made. You're going to be fine, but you are, you know, not awake. And so someone needs to make a decision for you. So you would appoint, you know, usually loved ones, you know, to make these decisions for you and discuss with them what your wishes would be so that they can carry out what your wishes would be in the event they need to act. Another healthcare document is called a living will. It is sometimes called an advanced medical directive as well. Generally, those terms are used interchangeably. It does not appoint anyone to make decisions on your behalf, but it does state your wishes, usually with regard to end of life treatment. And so I believe the workbook that Ryan mentioned earlier has a sample advanced medical directive in it that is tailored to the Catholic faith. And so I would encourage you to take a look at that. But you're, you know, in this type of document, you are usually stating what your wishes would be in the event, you know, you can no longer make your own decisions, and you are at the end of life. So what type of treatment you would want to receive, that kind of stuff. Okay, next slide, please. All right, so the sort of most common document you think of when you are thinking about estate planning is a will. So this is, you know, where you state who will receive your property at your death. It also usually appoints someone to be your executor after your death. So that is the person who becomes your legal representative. They would step into your shoes and be able to close out your affairs. And so it's very important to have a will, so that you can have more certainty about what's going to happen to your stuff and who is going to be in charge after your death. If you do not have a will, North Carolina and every other state where you might live at your death has a statute that says who gets your property, but it's not necessarily who you might think. So in North Carolina, if you're married and you have children, your surviving spouse and your children would share in your estate. Usually, our clients, if they have a surviving spouse, would want everything to go to, or at least for their benefit, so that their surviving spouse could use property for their children, but could also use it for themselves. And so, if you know, if that's what you would want as well, you would need to have a will that says that. It can be problematic if you don't have a will in that scenario and your children are minors. Minors can't legally inherit property without some structure in place for them. And if there is not one yet, it would be a guardian that gets appointed by the clerk. And the guardian has to report to the clerk each year for every transaction they do with the property of that minor. And so it can be a pain and you want to avoid it. And so if you have a will, you can address that situation. In North Carolina, if you don't have a will, and you're married, no children, but you have parents still living, your parents and your surviving spouse would receive your property, which is typically not what people would want. So again, it's just really important to have a will so you can specify exactly who receives your property at your death and who is going to be in charge of distributing it. So if you have a will and you pass away, what happens is the executor that you've appointed in that will takes it to the courthouse and what's called probates your will. So that that means it is declared by the clerk as your last will and testament, and it gets put on file. And then your executor collects your assets, reports those assets to the clerk of court, pays fees on those assets, and then distributes them according to your will. This is what's typically called the probate process. It can be time-consuming and cumbersome. It can be a good idea to try to avoid it to the extent you can. And one way to do that is with a trust, which I will get to in a second. So any asset that is just in your individual name and does not have a beneficiary designation and is not in a joint account with a right of survivorship is going to go through the probate process. You can avoid this process if you have assets in a joint account that has a right of survivorship. or if it has a beneficiary designation like life insurance, the beneficiary would receive that property and it would not be typically subject to the probate process. I'll caution you though, it is not always a great idea to, convert your accounts to joint accounts with someone else unless it's your surviving spouse with your spouse. If you do that, you are potentially subjecting that asset to the debts and creditors of the joint owner. And so you just want to be very careful about doing that. We typically do not advise clients to put, say, their children on an asset with them. It can create problems, and it's much easier to deal with that through a will or a trust than to make them a joint owner and then find out later on that a problem has arisen because of that. Okay, next slide, please. Okay, so I mentioned this earlier. A trust is a way to help avoid the probate process. So when you set up a trust like this, it's called a revocable trust, sometimes a living trust. There are all types of trusts out there. But in this context, we're talking about a revocable trust, which means you can change it at any time. When you have a trust like this, you also have a will, but we typically say that the beneficiary of your will says the beneficiary is your trust. We call this a pour over will. It sweeps things into your trust that you have not put there before you pass away. The benefit of a revocable trust like this, there are a few benefits. So first, it can help avoid probate on an asset. So if you retitle an asset, say an investment account, not an IRA, but just a typical investment account, if you retitle that into the name of your trust before you pass away, you avoid probate on that asset. So you avoid fees on that asset and you avoid having to report it to the clerk of court. That can be very helpful for assets that can be that have lots of activity going on. Any activity with an asset like a brokerage account that has dividends, interests, reinvestment, all that stuff, you have to report all those transactions to the clerk of court. So if it's in a trust when you pass away, you don't have to worry about that. And the other benefit of a revocable trust is privacy. So your will, as I've mentioned before, gets recorded at the clerk of court's office and becomes a public record at your death. Your trust typically never gets recorded. It's always private. So if you have a revocable trust and a pour over will, again, that's a will that leaves everything to your trust at your death. When your will gets filed at the courthouse, all anyone is going to be able to glean about your beneficiaries from that will is that it is your trust. So they don't get a copy of your trust and see who your beneficiaries are. That stays private within the trust document. You may be thinking, okay, if I'm setting this trust up, what does that mean for tax purposes? How does that work? So revocable trusts like this, while you are alive, are not separate from you for tax purposes, for income tax purposes. If you were to title an account like a investment account or even just a savings account in the name of your trust, you would give the bank your social security number to use as the tax ID number for that trust. That means that you don't have to file separate tax returns for a revocable trust. It really is for pretty much every purpose, it is you by another name. But when you pass away, technically an asset that is in the trust is not in your name, and so it does not need the court supervised probate process to transfer title of that asset to your beneficiaries. So in your trust, you would name a trustee after your death to distribute property. And so your trustee outside of the purview of the clerk of court would distribute your assets according to what your trust says, so in a private manner. So that's the main benefit of a revocable trust. There are other types of trusts that are irrevocable, meaning you can't change them. Those can be great tools for leaving assets to minor beneficiaries, or any other individual that you are concerned may not be able to manage their inheritance well. And so those types of trusts can be done in a revocable trust. They can also be done in a will. We typically have them set out in a revocable trust. So they say at your death, this trust for your 10-year-old child is going to receive your inheritance, and the trustee will manage that property on their behalf. So that's another type of trust that can be useful. But when you're setting up your estate planning, you're typically not going to set up an irrevocable trust that would be in existence as of that day, unless you're using it for say tax planning or something. You would just have a revocable trust that then spells out how your property would be distributed at your death, which may be to a new irrevocable trust at that time. Okay, so next slide. So this is, I think this is covered by the workbook that Ryan mentioned earlier, but this deals with the healthcare living will advanced medical directive. So there's certain provisions that the Catholic faith has directives on, and so it is a good idea to consider those things, and in that workbook, consider what it says about these issues that are not addressed by your typical living will form. So the North Carolina legislature has a form that they use for living wills and advanced medical directives, but of course, that form does not address any issues of faith, and so it's a good idea to take a look at that workbook and work through these issues with not only your attorney, but also your priest and your family, so that you're all on the same page about making sure your wishes are taken care of. Next slide. This is another area that can be addressed in your advanced medical directive. So how you want your remains to be disposed of after your death. And so, you can specify this in that living will. There's usually a customized form. The most important thing to remember is, as you're working through these issues with your attorney and your priest, as you talk about these, and make sure that what you want to have happen is expressed in those documents, and also that your loved ones know what you want as well, so that everyone is on the same page and there are no surprises down the road. Okay, next slide. So I've alluded to this already, but an important part of the estate planning process is not just the documents, but it is making sure your assets are titled in a way so that everything sort of works in sync at your death. So again, if you have a joint account with a right of survivorship, the joint owner is going to become the owner of that asset after your death. So that's very common with married couples. And so that is part of your estate plan. So if let's say you're a surviving spouse, you're a widow, you've got 2 children, and you want a child to help manage your finances. If you go to the bank and put them on the account, make them a joint owner, they will have that access to help manage your finances, but at your death, they also will they will inherit that account. And that may not be what you want to have happen. You may want that account to be split evenly between your children and not just go to the one that's on the account. So it's very important to review these things. Usually we recommend that you just use a financial power of attorney in this circumstance and not put your child on that account. But you need to review that. It's also important to review beneficiary designations. So if you've got life insurance or retirement accounts, and you have minor children that you want to inherit from you, you need to make sure your beneficiary designations will designate the trust for them as the beneficiary instead of designating the child individually. You could have an excellently drafted estate plan, but if your asset titling and beneficiary designations are not aligned with the documents that have been drafted, then those documents aren't going to work the way you want them to. Another important asset to consider is real estate, particularly real estate that is not in North Carolina. So if you have a vacation home, say in South Carolina at the beach. If you own it individually at your death, you will have to have both a North Carolina and a South Carolina probate in order to pass all of your assets. If you instead have a revocable trust and you put your South Carolina vacation home into the trust at your death, you can avoid a South Carolina probate proceeding. So these are all important things that you need to consider with your estate planning attorney when you're setting up your estate plan. So again, it's not just a set of documents. It really is a whole process of reviewing everything and making sure it's all going to work the way you want it to when the time comes. Next slide. Okay, so this just sort of summarizes what we've said already. It's important, get the documents, review asset titling, and then review your plan every so often to make sure the law hasn't changed or your situation has not changed in a way that would make it useful to make changes to your documentation. We recommend that clients come see us every 4 to 5 years to check in on things. We hope your documents will work really well for much longer than that, but 4 or 5 years is enough time to have your circumstances change. You might have new grandchildren after a few years. You might have a terminal prognosis, and we need to make sure your documents are going to work correctly in a very short period of time. So it's a good idea to regularly review this and notify your attorney if you do have a change in life circumstances, so we can make sure your plan is going to work the way you want it to. All right, next slide. All right, so that's it for my part of the presentation. I'll be on. I can answer any questions if we have time for them at the end, and I'm also available for questions later on if you want to email me. But I'll turn it back over to Ryan, and hope everybody has a great day.
Charlie, we just one question. We have a lot of great questions, but one of them that did come up. Maybe you can expound just a little bit of why it's not maybe a good idea to put an individual's primary residence in the name of a child and taking out of their estate.
Yeah, great question. So there's a couple reasons why you probably don't want to do this. So if you do that, it does help avoid probate, or it can if you have if that child is a joint with right of survivorship owner. And so you may think, well, I should do that because it will help pass my assets free of probate. The issue is twofold. So first, if you do that, you are subjecting that property to the claims of a creditor of that child. Now, you may have the most responsible child in the world, and you think there's no way they would ever get sued. And that may be true, but anyone can get in a car accident. Your child, if they're a professional like a lawyer or a doctor, they can get sued for malpractice. And so you are subjecting that property to the debts of your child if you put their name on it. The other issue is for income tax purposes. So currently, if you own a capital asset like a piece of real estate or a stock or a bond or something like that, when you pass away, your beneficiaries will receive a stepped up income tax basis in that property. And what that means is, so let's say, you purchased a piece of real estate for $100, one day, many years ago, and now it's worth $100,000. If you were to sell it, you would owe tax on the difference between $100,000 and $100. If you gift property to someone, and that would include by adding them to the deed is a gift to them, they will receive an income tax basis in that property equal to yours. So when they receive that property after your death by right of survivorship, half of that property you would have already gifted to them, and they don't get an income tax basis step up on that half. Or if you gift the entire property to them, they would not get a stepped up basis on the whole property. So if they go to sell it, they're going to owe income tax on a lot of gain. If you hold on to that property until your death and you leave it to them in your will or in your trust, they get their income tax basis becomes the fair market value of that property on your date of death. That means they can sell it the next day, and assuming they sell it for its fair market value the day before, they will pay zero capital gains tax. So holding on to a capital asset like that can really save your beneficiaries lots of tax. And so before you transfer any asset to a child, it's a really good idea to consult with an attorney and make sure you're not creating a tax problem for your child, or a creditor problem for yourself.
Okay, thanks, Charlie. We're going to
Sure.
go through the last few slides here quickly, and then we have a few more questions, Charlie, if you have a few more minutes.
Yep, definitely.
Okay, all right. So next slide, please. A number of events here with the foundation. We have the Father Price Society. This is for anybody who has already named their parish or a diocesan ministry in their estate plans. They're welcome to become members of the Father Price Society. The highlight of this is that the bishop gets to thank you while you're living. We have an annual mass and luncheon, typically the last week in October, that you'll be invited to. So please let us know if you wish. Next slide, please. The Home Mission Fund, as Maureen spoke about earlier, this is to help build churches and parish facilities in the more rural counties of North Carolina. So you can set up a gift for this, or give during your lifetime for this fund, but it's helped a number of parishes, especially in the more rural and poorer places of North Carolina, build very nice churches and halls and things like that. Next slide. And the Seminarian Partnership Program. We have a number of endowments that have been set up to benefit our current and future seminarians. People also are welcome to make outright gifts to fund our Seminarian Partnership Program. The BAA does help with this, but it's for just the administration of the program. Our fund helps them with their education and their formation. As you can see there, cost of tuition, room and board, insurance, travel, things like that. So if you'd like to help a seminarian specifically, the other thing here with the Seminarian Partnership Program is that you can restrict your gift just for the seminarians. Gifts to the BAA are great, but they're divided amidst all the different ministries. A gift to the Seminarian Partnership Program will just support the seminarians if that's what you wish. Next slide. And then the questions. We've got a number of good questions. A number of them we have covered throughout the presentation. And Charlie just answered one that a number of people had too, regarding the property to the children. One of the questions, another question here, Charlie, is a person asked how best to keep, their planning is done, but how best to keep things organized and file for family and things like that. How do you keep all that together?
Yeah, so we think these days it's a good idea to have everything electronic, so that you can share documentation with your family as needed. You will need the original will, when the time comes, and you may need the original financial power of attorney. But if you've got everything in a PDF format that you can share with them, they'll know that it exists. And then in that email, you can also, let them know where the originals are. Some attorneys will hold on to originals. My law firm does not. But we tell people, keep it where you keep your important stuff. So if you have a file cabinet at home, keep it there. If you have a safety deposit box, you can put things there, although just make sure someone else has access to that box, so that they can retrieve it after your death. But really, communication is key. Make sure people know where your documents are, and know, if they've been, appointed as a certain, in a certain role, that they have a copy and are ready to step up if need be.
Okay, thank you. Another question is a person who has, again, completed her planning, but asked if she does want to make an additional gift, um, to a fund here at the foundation. How does she do that? Can she do a codicil, or does she have to rewrite the whole will? What's the best way to do that?
Yeah, it really depends on what your current documents say, and also your current asset ownership. So you can do what's called a codicil to a will, which is just a fancy word for an amendment to a will. If you have a trust, you can amend your trust to do that. Um, you can also use an IRA or life insurance to do that. As Ryan mentioned before, IRAs are great for leaving to charity. So you get more bang for your buck when you do that, because if you leave an IRA to a beneficiary, typically they're going to owe income tax on it. If you leave it to a charity, they don't owe income tax. So you can do it, in a number of different ways, and it's just a matter of reviewing what you currently have, what your current estate plan is, and figuring out the best way to do that.
Okay. Second to last question here. There are things that are there things required to be done in Wake County when a person dies with a will? Creditor notification, filing the will, sharing will with the family. I know it's a lot there, but maybe you can give a quick summary.
Yeah, so Wake County it's the same as any other county in North Carolina. So the probate process I mentioned earlier, you'd have to file what's called an application for probate, which is a court form that lists, your name, who the beneficiaries of the will are. You file that with the will at the courthouse. Your executor is the one who would file it so that they can get formally appointed as your executor. And so the one thing about Wake County that is maybe different than some other counties is that it is very backed up in the clerk's office. So if you do live in Wake County and you have potentially significant assets, it's a good idea to consider having a revocable trust so you can avoid the probate process and having to go through it in Wake County. It just takes, because they have so much to do and probably not enough staff to do it. They just get behind, and it can take time. And so if you have a trust, sometimes you can cut down on a lot of that time to pass your assets on to your beneficiaries.
I'm just going to jump in, Charlie and Ryan, with a couple more questions that have come through on the chat box. There is a question: can both the son and daughter be listed as a power of attorney and healthcare power of attorney? So that's question one. And
Yeah,
when
that can definitely happen.
Charlie will take that.
We have clients that do that all the time. So there's a couple things to consider in that. So it used to be more difficult for a financial power of attorney to have two people listed together. It was certainly possible to do it, but it used to be that agents typically would have to act together, which meant that if you needed a check signed, you needed both of them to sign that check, which can become a logistical issue. There's a new North Carolina power of attorney statute that by default says joint agents can act independently of each other. And so that it can cut down on some of that. Not all banks always honor that initially, at least. And so having two people can be logistically a little more difficult than one, but it certainly is doable. From a healthcare power of attorney, it's less of a problem if you have two people. Doctors are gonna work with who's available. So if you've listed both of your children and one of them just is not available and a decision needs to be made, they will rely on the one child that they can get in touch with. So it's certainly doable, and we have plenty of clients that do it. It's just you just want to consider the logistical concerns of having two people serving at the same time.
Great, thanks, Charlie. And just one last one. When should they start this person start a 529 for grandkids in the college education? I know that's not really our wheelhouse, but can we provide some direction there, please?
Yeah, so I think I don't think you can start one until the child is born. But once that happens, I think it's fine if you have the funds to do it. It probably makes sense. You should certainly consult with your financial advisor on the issues like this. But I think once a grandchild is born, you can certainly start funding a 529 plan, which would give it more time to grow in value, depending on what type of investments it has. Um, I think there was another question about what to do with a 529 plan if a child has already used all of if they've already finished their education. And that's an interesting question. It comes at a great time. The Secure Act 2.0 that Ryan mentioned earlier has a provision in it now that you can convert 529 plans in a limited amount each year. I think it's like 6,000 a year. But you can convert those to a Roth IRA for that individual, and so that's a great way to start retirement funding for someone just out of college. So you know, you can also change the beneficiary typically of 529 plans so that if one child doesn't need it all, uh, and someone else can use it for educational expenses as well. But that new Secure Act 2.0 provision that allows essentially a Roth conversion of a 529 plan could be very, very useful.
Okay, and Charlie, last question here as a theme is just if people don't know who to choose for an executor or power of attorney, I know some law offices serve in that capacity. There may be also other groups, retired judges or attorneys that may also serve in that capacity. I'm not sure if you're familiar with any in this area, but how does one go about, finding an executor of power of attorney if they don't have one?
Yeah, it's a great question. There's not really an easy answer for it. So hopefully, you've got a family friend or someone that would be willing to serve. Certainly, if your executor can get compensated. They can get paid for what they do. Um, you could also leave someone, some amount of money as sort of a gift of appreciation for serving. So that may help get someone to agree to do it. Some attorneys will serve. We typically do not. We, it can create conflicts of interest if you're both the attorney and the executor, but they can be overcome. We just choose not to. CPAs will do it sometimes. Other professionals. So consider expanding who you might consider to do this. So you may not have children that would serve, but do you have a good friend that that you love and loves you and would be happy to do this? And if so, do you want to leave at least some small token of appreciation to them, to thank them for serving, for a non-family member?
Okay, well, thank you very much. It was great questions, everyone. Thank you all for your participation and your generosity towards the church here in Eastern North Carolina. If you do have questions, we are more than happy to help. Again, as I mentioned earlier, no cost, no obligation. We're here to serve you and to help you with your planning process when things are put together. And then we have people like Charlie and other wonderful attorneys to make everything official. So again, reach out to us. Let us know if you'd like to set up an in-person meeting, a phone meeting, a video conference. We can meet here at the foundation at a location that's convenient for you. Just let us know. Alicia, do you have?
Thank you both to Ryan and Charlie for presenting today. Please know that I will send an email out to everybody with both Ryan's and Charlie's contact information, and that you can write to that email if you wish to also have your workbook, the estate planning workbook and the medical directive mailed out to you. Thanks very much for your time. The recording for this will be up on our website tomorrow morning. Have a great day.
Thank you, everyone.